Good evening, everybody. My name is Sam Shihab with the law firm of Shihab Burke, and with me,
Brian Burke from that very same place.
Today we're going to be talking about what we started last week, Brian, about the executive orders. When we got together last week at 6 o'clock Eastern Time, it was the day President was inaugurated, Trump was inaugurated for a second term. We were hoping that we had something to talk about, and there wasn't a whole lot official. Now we have some official executive orders that were released later that evening, and obviously the interpretation of it, and some of it has been enjoined by court action. So we're going to do kind of a wrap-up, an overview of what happened and what to expect, and few practice pointers for you guys about what we're seeing in 1 week of the new Trump administration. So everybody's talking about executive orders. And really, there are other things that are not in the executive order that are also very important to talk about. Before we dive into these things, Brian, a little introduction about us. We are immigration attorneys. We practice immigration law in the U.S. and throughout the world. We do employment immigration law and family immigration law out of our Dublin, Ohio office. Brian is my partner and my friend, and we've been doing this for quite some time. We get together every week on Monday at 6 o'clock to spend an hour with the community and see what we can do to exchange information, learn from you perhaps, and also learn, maybe share some information we know. What is an executive order, Brian?
More or less a proclamation by the president. It's, you know, it's not a law, it's not a regulation. It's something that just comes out of the mouth or really the hand of the president. It's a signed policy from the executive branch of government. Yeah.
Can the executive order change the law?
No, but it can change how perhaps the law is interpreted or executed, for sure.
So, so the president belongs to one of the three branches of the government.
Sure.
The executive branch, and he is the head of the executive branch. There are two other branches in the U.S. One is the congressional, or in other countries they call it parliament. Here in the United States they call it Congress, the legislative branch. And then we have the court, the Supreme Court. Each party has a role.
Yep.
Congress writes the law, president executes the law, and the court interpret ambiguous laws that are unclear.
Interpret the law,
Yeah, unclear, you know, they make a ruling on it. The president cannot, by an executive order, create law because of two things. This is not a dictatorship. This is a democracy. And that function is reserved to Congress to protect people. It's called separation of powers. And Congress, their job is to interpret the law. Now, the executive order, what it does, it basically instructs the executive branch, basically all the other agencies under him, Homeland Security, Department of State, all of them under the president, to execute the law. And the policy could highlight certain laws that require special attention because due to the current circumstances, they are important. And that's what an executive order. And when an executive order exceeds the law or exceeds the Constitution,
seems like it's all building up to something, Sam, but
it is illegal. Okay? Now, multiple, you know, I think he had a whole slew of executive orders. The one related to us, obviously, the immigration, is the Birthright
that's a good place to start,
that he has signed into law, that has now been enjoined by a judge already.
What do you mean enjoined? Stopped, held off.
Yes.
Stopped from being enforced, right?
Stopped from being enforced because they believe, the court believes, it's possibly unconstitutional. So what's in that executive order, Brian?
So, you know, last week we were here talking, Sam, we were saying, well, what we're hearing about this executive order is only going to touch upon people who are here illegally, right?
We were wrong.
Yeah, that's what the news is reporting. So the short answer is the executive order on birthright citizenship said people who are born in the United States to essentially mothers who are here unlawfully and the father's not a U.S. citizen or permanent resident, those children are going to be not U.S. citizens. And they also said children that are born to people who are on lawful non-immigrant visas, like H-1B, L-1Bs, those people, unless, again, the father is, a U.S. citizen, permanent resident, aren't going to be considered citizens. So basically, the sort of jaw-dropping surprise that we got on Monday evening when they put the text of these out is that they said, if you're here legally on a non-immigrant visa, we don't think your children born in the United States should be United States citizens.
Which was a shock.
A shock, because raise your hand if you've read the 14th Amendment that covers this issue. Raise your hand, Sam, you've read it. Sorry, you have to do my shtick. What is the Constitution? You and I, everybody was watching the football game, but the bottom line is the U.S. Constitution that says those who are born in the United States and subject to its jurisdiction are citizens of the United States. And the response from a bunch of attorneys like us is, how can somebody be born in the United States and not subject to its jurisdiction, with the exception of diplomats who have a sort of special carve out there? And I guess the courts agreed with our, maybe we're agreeing with the courts, but the bottom line is the courts, let me see, who sued on this? I think it was maybe 22 states it got up to. Yeah. 22 states plus the ACLU sued various spots around the country to basically challenge this. And the first court that got to it, I think it was out of Seattle, basically said, unconstitutional. We're going to stop enforcement of this while the courts, hear this out. So there's an executive order out there, a nasty one by my description of it, that says no birthright citizenship for children of lawful non-immigrants, and that's been, as well as the children of those unlawfully present, and that's been put on hold by a court for the time being.
So I'm sure the president had discussed this with his legal team.
No doubt.
And because obviously this is a big one. He has been complaining about this for a long time.
Yeah.
And the president is 100% aware that what he's doing was unconstitutional. He is.
Hey Sam, unconstitutionality is not determined until it's decided by the Supreme Court. I will give him that. You don't really know for sure until until you're at the Supreme Court, because they're the ones who make the final decision, right?
You don't have to wait for the Supreme Court to know that every person is innocent until proven guilty, that everybody born in the United States is a U.S. citizen, subject to the diplomatic exception. You don't have to hear from the Supreme Court. It's my opinion that the president knew that what he's doing is unconstitutional. However, he did it because, number one, he promised to do it. It's a political statement, and it's like what Trump does. He requests everything and then negotiate for something less.
I do agree with that.
He is putting this out there. He knows that it is going to be struck down and it will be appealed to the U.S. Supreme Court, and he's waiting for the U.S. Supreme Court to give him some hints about another way to do it that may be legal, or to do it halfway. The U.S. Supreme Court he's going to feel the water. He's going to see how the Supreme Court respond to his very egregious executive order that he knew is going to get struck down. And based on what the Supreme Court weigh in on the subject, he is going to, just like what he did with the Muslim ban. It was revised 3 times before the last time it became a little bit more something that the U.S. Supreme Court would allow. Yeah. So the same thing here. He's doing that. So we will wait to see what the final version will be.
Well, yeah, so I'm going to maybe talk about what's the path forward. So it's a court case now. The court said, whoa, enjoined. This is not being enforced until you win in court, government, because you're essentially going to be hurting people. We don't want to give you the benefit of the doubt on this one.
So a pause for everybody to understand. So right now, of course, it was not going to take effect until 30 days from last week, so it gave it 3 more weeks. So right now, until the U.S. Supreme Court weighs on it, which I don't think is getting any expedited movement. I don't think it's moving slowly. It may take months before it gets to the U.S. Supreme Court. But and also the U.S. Supreme Court is going to sit down and look at the appellate court. But right now, everybody understands.
It has to go through this court. It's going to go to an appeals court, and then it's going to go to a Supreme Court. Yeah.
Until the court rules, your children are U.S. citizens, born here in the United States today, tomorrow, next week, the week after, until the U.S. Supreme Court, the executive order is gone.
Yeah.
Until the U.S. Supreme Court weighs on it, and that's going to take months.
Yeah.
I don't think it's the kind of thing that there's any urgency on it. This law has been in effect. There's a U.S. Supreme Court in 1800 that you and I were looking at.
1897, something like that.
Late 1800, that said people born in the U.S. are subject to the jurisdiction of the United States, and therefore they are U.S. citizens by birth per the Constitution.
Yeah.
And therefore, your children born today, next week, next month, and the month after are U.S. citizens until the U.S. Supreme Court rules in its favor, which will be very interesting to see what's going to happen. I think as written, this, I'm comfortable in saying as written, it will probably be struck down by the U.S. Supreme Court, and it'll be interesting to see if they give him an opportunity to modify it with something less than that.
Yeah, so what you're talking about, Sam, is basically when the Supreme Court says, hypothetically says, that's unconstitutional, you're not allowed to do that, President Trump, they are going to basically explain why, and that explanation why might give an idea as to how, if somebody wanted to change this rule, what it would be if it's anything less than changing the Constitution, bottom line.
Yeah, so yeah, exactly. I mean, the U.S. Supreme Court can do one of several things. One, they can, if the appellate court agreed with the lower court that it's unconstitutional, the Supreme Court can refuse to hear it, which is unlikely.
Yeah, leave that, you know, that, as in thumbs up, that appellate court decision, striking it down was perfectly fine. We're not going to touch this thing,
Yes. I know, in the next few weeks, other courts somewhere may rule in its favor.
Yeah. Yeah.
And that would create the opportunity for the Supreme Court to take it. When the different courts rule differently, it creates confusion, and then it goes to the U.S. Supreme Court. They can completely reject it and be silent, which is, they're not known to do that. They will write all kind of details as to why, pages and pages of it. And they may give the president a hint about how he can redo.
I don't think he can. I mean, I don't think if the Supreme Court's being honest that there's a way to do it without changing the Constitution. I'll spare everybody maybe the longer talk about this, but again, subject to the jurisdiction of the United States, how do you say that somebody is here in this country and not subject to the jurisdiction, you know?
Well, 1898 or 1880 something, and today is a long time.
Yep.
And a lot has happened since then. And to the extent that there could be an interpretation, otherwise we will find out. Well, we don't know.
Well, the reason why
I see your way, but you know, I can
positions, which is what I like.
I can think of one justice where 100% agree with Trump. I'm not going to mention who. I can think of one, but not more than one.
Yeah.
And you have four liberals who are not going to agree, probably, and they only need one vote.
To shear off from the conservative bloc of the Supreme Court to basically say no.
No. And if that happens.
Yeah. And we had our big all-along talk a couple of days ago to basically who's likely to be shorn off and to agree with the liberals, and you know we think
Yeah. So what is going to happen? It will be interesting, but today, next month, and the month after, until the U.S. Supreme Court takes that order and do something with it, which will necessitate a rewriting of that executive order, most likely by the president again, your children born here in the United States are U.S. citizens.
Yeah.
And that's what I want to communicate.
Yeah.
Okay. So that's the birthright citizenship and piece. And government hiring freeze.
Yeah.
Again.
So there's a government so one of the executive orders was a government hiring freeze, and you know, as to how long these things last, you know, that's something that's going to be up in the air. But why is a government hiring freeze important? Because well, government employees process your immigration cases. If I wanted to think about the biggest government hiring freeze that sticks in my head is during the prior administration, the freeze of the Department of State. One of the big problems we had during the prior Donald Trump administration was the Department of State was just absolutely starved for employees, and they couldn't get any more. and that slowed things down at the consulate profoundly. And I guess but I mean, it can really, the longer a freeze goes on, it's basically, during the prior administration, you had people quitting in protest. Our colleague Joe pointed out that, if there's a government hiring freeze plus a return to work mandate, right? Well, if all those people who don't want to come back to the office, quit their jobs, suddenly that's a big old reduction in the government workforce. And obviously out there, I guess this has to be a larger part of that planned desire to reduce the government workforce. And, even though it's a common joke that government employees don't do work, they do process your immigration cases. And that's that, I guess, is the bottom line. It's, if there's a government hiring freeze, it seems that no doubt the net number of employees, all it takes is a retirement or quitting, and we're down. I have no doubt we're down government employees right now.
Yes. Yes. So there is a overnight firing of employees on the top level in various sectors. The top 4 asylum officers were in the U.S. were fired overnight. A moratorium on refugees and freeze on asylum, and there's all kinds of things in that area, which I think probably some of it needs some cleaning up about time, to be honest with you. But yes, the government hiring freeze can impact us. We'll see how that works.
Yeah. Does that mean, to be clear, I'm just reading, I have the executive order up here. Within 90 days of this memorandum, this is the hiring freeze, yada, 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 the government agencies shall submit a plan to reduce the size of federal government workforce through efficiency improvements and attrition. And that's that. Getting rid of people is the plan. And
then there's a return to work mandate.
Yeah.
Because all the U.S. government employees, or a lot of them, are working remotely, and it really I have to agree, it has caused a problem. I won't be surprised that it's part of the reason why we're getting that huge backlog in immigration, is how efficient these government officials are right now. It has become a problem.
Well,
some of that stuff is positive. And helpful. Let's get those guys back. all these guys issuing prevailing wage determination on the Labor Department is taking 7 months.
Those departments. I don't know if I believe USCIS has gotten any slower, working, with the option to work remotely. But Department of Labor sure is slow. That's the bottom line.
Well, unless you're working for a private entity, 7 hours, 8 hours at home does not mean 7 or 8 hours working, and the oversight is who knows.
Yeah.
All right. So the third one, which is protecting. And I have it here, protecting the United States from foreign terrorists and other national security and public safety threats, executive order. Okay, that's a mouthful.
Yeah.
So, interesting executive order, which basically has instructed Homeland Security and the Department of State to come out with a list of countries that have a lax document controls to issue the travel ban to these countries. And obviously, these countries are not identified formally now, but there's talk about countries from like Syria, Iraq, and Somalia, perhaps, and a few other countries that we will have a travel ban. So Muslim ban 2.0.
Yeah, I think you're probably focused on the same language as me. Their goal is identifying countries throughout the world for which vetting and screening information is so deficient as to warrant a partial or full suspension of the admission of nationals from those countries pursuant to parts of the immigration laws right there. Yeah.
And the other one, it says here, identify how many nationals from these countries have entered the United States since January 20th, 2021, magic date.
Yeah, what's the significance of that date? I don't know,
And any other information the secretaries or attorneys general deem relevant to the actions or activities of such nationals since their admission or entry to the United States.
Well, so the point is, I guess, is all this is probably going to result in some sort of new travel ban, right?
And find ways to deport these people.
The bottom line is, Sam, we were talking last time, our last Monday was, what's the result of all this going to be? Lawsuits, 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 and this falls in that category as well, because I fundamentally have a problem with making, wholesale people from an entire nation, we can say, nope, we're never issuing a visa to that nation again. I don't like it. It irks me as an attorney, as an American, to make blanket decisions based upon your country of origin. I mean, people from certain countries already experience incredibly long visa processing times, for example, for immigrant visas, because Somalia is a great example of that.
How about evaluate visa programs to ensure that they are not used by foreign national states or other hostile actors? So that opens it up to anybody.
Yeah.
Or, this can be anywhere. It doesn't have to be from these countries, anywhere in the world,
Yeah.
okay? To harm the security, economic, political, cultural, or other national interests of the United States. But isn't that what we've been doing always? Who have been allowing people and issuing them visa who are posing a security, economic, or political, or cultural harm to the U.S.? Ever in any history in the country, under any president.
Yeah,
so
I don't think the visa officers are constantly going and saying, yeah, I think
he's going to harm us, but I'm going to give him the visa anyways.
Yes, those guys can deny you because they don't like the way you're dressed today, and you'll never know because they have it's the doctrine of consular non-reviewability, that the consulate can deny you for failing to meet the requirements, and you can't really challenge it. They have that right under the law to deny visas for any reason. So I guess, if they're talking about, generally, Sam, increasing scrutinies on visa applications and the rate of consular non-reviewability allows them to basically not review a visa denial, it sounds like this could be fairly serious, right? For anybody. I mean, if Sam, I'm going to maybe talk for a minute about the concept of consular non-reviewability. People come to us all the time and they say, hey, Brian, my visa's denied at the consulate. They denied the visa. And what can I do? Can I appeal it? The answer is no. If they make a decision on your visa application, you're, for most intents and purposes, done, right? Sometimes they're willing to hear you out if you have, more documents to give them. But, there's something built into the law, the concept of consular non-reviewability, that, you can't go to a court and challenge a visa denial because they have that power to deny visas for national security and about 10 different other reasons.
Well, how about this one?
Yeah.
This is one of my favorite. Evaluate the adequacy of programs designed to ensure the proper assimilation of lawful immigrants into the United States and recommend any additional measures to be taken to promote the unified American identity and attachment to the Constitution, laws, and founding principles of the United States. So you can go in now to a community, Chinatown, and break it up.
Yeah.
It is not, or is it? Does it promote the unified American identity?
Yeah. Well, I mean, I think of that in a very narrow way. So, hey, you're going to the United States. You're going to go to their visit. You want to see Disney World. Are you American? Are you interested in our ideals? If you're coming on a working visa, are you?
No, lawful immigrants.
Oh, okay.
Not visitors.
Oh, sorry.
Okay, these people who have green card holders who goes into Chinatown, Irish town, Greek town, Arab town.
Let's do this. It sounds like a very nice series of dinners for us, Sam, as an aside. But I see your point. It's basically,
this is an executive order, Brian.
Yeah, this is an executive order. But Sam, I want to take a step back from this. This is what they're proposing. They're saying you have 90 days to look into these things, right? 90 days, come with a set of, 30 days, 30 days. 30 days on this one. Basically, check out your vetting. Basically, make sure immigrants are assimilated. All these things are going to result in another executive order that's going to basically be challenged in the courts. Wouldn't you agree?
Yeah,
Yeah.
absolutely. Yeah. But I mean, is this illegal? The assimilation piece?
I'm gonna
unified. I mean, what is that? I mean, I'm confused.
I mean, I'll give you a common one. There's tons of permanent residents who can't speak English, Sam, right? And
English is not the official language of this country.
Yeah, but it's the official language of U.S. citizens. English is part of a citizen.
Not if you grew up in Miami.
See?
I mean, just by way of example.
Yeah.
I mean, yeah. But yeah, that's a conversation we can have forever. Anyways, so that is the Protect America. So this is a very broad executive order. I don't know if this is just to make people happy executive order, or is this
Doesn't make me happy.
what comes out? Well, certain people, not you. It's not. It's not. It's
Hard to
not
make me
for
happy.
you. Yeah, but what comes out of it will be interesting.
Yeah, this is one where
We don't know what comes out of it.
they're banging the drum saying we are going to vet everybody more. We are going to go really kind of look in, but it seems like it's going to manifest something later. But
All right.
these things we have in our hands sort of dovetail
Yes.
well off of that.
Right. So a couple updates on advanced parole, Brian. What do you got for us?
So
this is today's
yeah.
information, right?
Yeah, I mean, so this is we're members of American Immigration Lawyers Association, AILA, and part of their job is to basically sort of apprise us of trends out there, and this one is relating to advanced parole, and essentially, basically, whether advanced paroles are being honored. And the answer is, advanced paroles are still being honored for people who are eligible for them, pursuant to whatever reason. For example, there's all sorts of like TPS advanced paroles saying these things are still valid, right? Fine, but
There is significant scrutiny at the border right now for advanced parole folks.
yeah, I guess that's
And
the short answer, yeah.
they have confirmed that your advanced parole that you have on adjustment of status is fine.
Yeah.
It shouldn't have any problem. But you need to understand that advanced parole are not guaranteed entry to the United States, and also you need to have supporting documentation for them. And this is what we know so far, because there has been a
Murmur of increased scrutiny, I guess.
yes,
on
there
them.
is definitely a discussion of attacking these parole, reviewing them,
Yeah.
and potential significant delays coming to the United States on advanced parole right now.
Yeah, that's I think
really what we need.
Yeah, I think that's really where it's at. And
Yeah.
sort of relevant to that. So if this notice about advanced paroles is about weird and strange scrutiny upon entrance, one of these things is a sort of another sort of solicitation from AILA telling us about an apparent trend out there of people with petition-based non-immigrant visas, like H's and L's, who are allowed to come to the United States with immigrant intent, intending to immigrate and stay on a permanent basis, getting denied at the border. So this is a sort of one where
They're denied at the embassy, Brian.
denied at the embassy.
It was the Department of State. It's a Department of State.
Oh, you're right. Wait.
Yeah.
Yeah. Sorry.
So,
no, yeah,
so there's a consulate denials.
Yeah.
There are consulate denials of H-1B and L visas based on immigrant intent,
no.
which is completely illegal. You cannot deny an H visa or an L visa if you have a green card application. And these denials
Yeah.
are not being sent back to USCIS to review the H-1B. They're basically shutting down the case and denying the case. Now, this could be an isolated cases, but clearly has made it to the alert for the American Immigration Lawyers Association, and they have identified cases in which that has happened. Now, it could be an officer that does not know what they're doing, and it could be a new trend. It's clearly illegal what they're doing. They cannot deny a case based on immigrant intent for H and L visas. Otherwise, you cannot get a green card application and file for an H-1B.
Yeah.
It's insanity.
Yeah.
So that is an alert made it to us. It's too early to see whether that's a trend or not. My guess, that's somebody who's not well trained somewhere, who's doing stupid things.
Somebody feeling overzealous and empowered with all these executive orders.
Or
upon,
ignorant.
Yeah, this is true. Yeah.
Or ignorant. So we do not know. We will keep you guys posted.
Yeah.
So that is what we have today. And obviously there's tons of stuff going on the non-immigrant, on the border, and the refugee and the raids. There's a raid in Chicago today, arresting people, criminals, and so forth and so on that we're not going to talk about.
Yeah.
We're going to turn our attention to answer some questions, Brian.
Yes, sir.
And as we tell you guys, we don't know enough to give you a full answer. We will give you an answer enough to kind of give you an idea about a solution or a direction that you may have. Clearly, you need to consult with an attorney of your choice to be able to get the answer you need fully, with a full understanding of the case that is yours. With that, Brian, that screen on top, if you can take it down so my neck doesn't hurt, that will be outstanding.
Fair enough.
And we'll take the first question.
All right. Here we are. Bing. From Saif Khan. I'm on H-1B and my I-140 is approved. I am filing for I-45. I want to know what happens to my I-45 if my current employment is terminated. So let me see here. And here's some follow-up questions here. Can I transfer my H-1B to a new employer with I-45 pending before 180 days, considering that my current employer has not withdrawn the I-140 application? And can I port after 1 month of filing I-45 under AC-21? So.
All right, so there's a lot going on here.
Yeah. And I want to maybe bring up the initial scenario here. H-1B and I-140 is approved. I'm filing for I-45. I want to know what happens to my I-45 if my current employment is terminated. So, well, Sam, this is maybe when I make a plug for that video series we have on our channel. You know, it's called Termination of Employment with Green Card in Process. There's Sam and I did maybe about 2 years ago at this point, maybe about a year and a half, a series of videos.
Hasn't changed.
Yeah, the law is the same. But maybe talk generally. Once you have an I-485 pending, what Saif Khan has in mind is the portability rules. The portability rules do not attach until your I-485 has been pending for more than 180 days, meaning if you lose your, if your employer says within the first 180 days of your I-485 pending, they no longer want you, they withdraw your I-140, you are ineligible for portability to keep your I-485 alive. And on that same scenario, what happens, the question of your H-1B, can I transfer my H-1B to a new employer with I-45 pending before 180 days? There's two distinct questions here. If you lose your H-1B employment, you have a 60-day grace period to file an H-1B through a new employer. Your I-485 is a separate question subject to that 180-day rule, meaning in a scenario where, let's say 30 days after your I-485 is filed, your employment pursuant to H-1B is terminated. If your employer does everything right, they should, well, one, withdraw your I-140 as well, and you have a problem. You have to get a new job within 60 days, and your I-485 is effectively dead. Whether USCIS figures that immediately and sends that notice of intent to deny or RFE on your I-45 remains to be seen.
Not likely.
Not likely, I would agree, but you have an existential threat to your I-45, and if somebody with a half a brain and knows what they're doing at USCIS discovers that fact, they should withdraw your I.
They don't have a half a brain.
I know. There's a reason why I said those things. It's setting a Sam conversational trap.
They have a full brain.
Yeah.
And they're not gonna, these are low chances and the risk you take, obviously, in a situation like this. If you get a request for evidence or a notice of intent to deny or anything like this, you just need to go to a lawyer immediately, hire a lawyer to look at the case in full details to be able to help you. But if you cross the 180 days, basically you are like on life support, let's say, between the time you were terminated and 180 days. But once you cross that, I think opportunities open up again.
Well, I'm going to basically, this is emphasis as to why it's good to talk to an attorney about the details of this, of your own choosing.
There's so many scenarios, so many facts that the answer can turn negative or positive based on that.
So it says, what if my employer does not withdraw the I-140 application? And the answer is, well,
it depends on when he does it.
There's no requirement that you be employed by your sponsoring I-45 employer. It could be possible they say, we don't want you right now, but we definitely have a job available for you when there's permanent residence available for you. So it's...
Sometimes they forget altogether.
This is true.
So there's a lot there to unpack with the question. So but here's the bottom line, what you need to understand. You got an I-45, it's in the system.
Yep.
You have an I-140, it's approved.
Yep.
You have a job, you're good. Now you're about to be terminated. When you are terminated, the timing of it, and there is multiple times that will affect the answer. The good news, the good one is beyond 180 days of the adjustment filing and the I-140 filing, because that opens up all kinds of opportunities. Prior to that, you're in a dicey situation. And to dive into that, you probably need a consultation with an attorney, or you probably need to go find our videos What are the title of them?
I believe it's either termination or change employer while green card in process. Is that
Change,
is
yeah.
that serious?
And maybe we can throw in the comment section at the
You know,
bottom.
I would bet that the Sam and Brian in that video said watching this video is no excuse for talking to an attorney as well. So I'm gonna.
Doesn't matter.
Yeah.
Always talk to an attorney,
this is true.
anyways.
Yeah.
But let's take the next one, Brian. All right. So my H4 expires on January 31st, and H4 extension approved until January 31st, 2028. Nice. I've sent my H4 EAD application on January 24th, Friday. How long does USCIS take to generate a receipt? That's a great question. That's an easy one, Brian. What do you think?
Increasing amounts of time yet to be determined. The exact amount of time it takes them to get they're slow in receipts.
4 weeks to 6 weeks.
Yeah, I mean, you may get it in like 2 weeks, but you know, I'm usually telling people like a month on getting a receipt notice for anything is relatively normal at this point.
Yeah.
So Surya says, I need to get a receipt on or before 131 for 540 days auto extension. If my receipt date is after 131, am I eligible to work in a grace period of 540 days? So, well, Surya, you need your receipt date to be before your current EAD expires. So not the actual getting the receipt in your hands before your EAD expires.
Yes. So yes, which you filed it timely, so you will get a receipt typically within a day or so. There's a receipt date, and there's 2 dates.
On every time you get a USCIS notice, there's 2 dates on it that you think of. There's the receipt date. It's the date USCIS actually received in their office, and there's the notice date.
Yeah.
And right now, there's an awful long delay between those things. Is the bottom line. And the automatic extension of EAD rules require the government to have received your extension before the expiration of it.
The reason they do a receipt date and notice date is because the receipt date, there's certain law that gives you certain protection, like the automatic extension, and then the notice date is the date they mailed it. And the reason they separate the dates is because they want to give themselves time to process paperwork. So, because a long time ago, there was no 2 dates, there was only 1 date, and it was the notice date only.
Yeah.
And there has been all kind of lawsuits and complaints about it because it doesn't give you the date that you actually have the law protection of the law. So they've created the date. They're going to say we're going to give you the notice late, but we're going to put the receipt date so you know exactly what date we've received it, so you can figure out what the law reads and when's the law kicks in to protect you.
Yeah, and to answer the final question here from Syria, if my receipt date is after 1/31/25, after the expiration of your EAD, you're not entitled to that.
Correct, but if they've received it before, if you're FedEx, if you've done it by FedEx or you've done it electronically, you're going to get a receipt date before January 31st.
Yeah, that's for
Today
sure.
is January 27th, right?
Well, yeah.
You've already mailed it. You're going to get it before January 31st.
Now, we're here talking about receipt dates and notice dates like he has no problem, or he or she, I don't know. But the practical problem is if you have an employer who says, I need to see that receipt notice in order to keep you working.
Leave,
you have to. That's an employer issue. Yeah. They might not have the evidence to show you're eligible to work.
You could try to have an attorney write you a letter, but again, the I-9 is the I-9. If the person is stickler, you may have to go into administrative leave because you do need that document, that piece of paper, to properly complete an I-9. But if they don't ask, you're fine, and you're not breaking the law. Yeah. All right. Sam and Brian, thanks for weekly live sessions covering crucial topics. You're absolutely welcome.
Yeah, good stuff. Yeah.
Yep.
So let's see here. Shrath Kumar has a substantive question. If court case on executive order spans over years but eventually gets passed, does it mean, based upon signed executive order, children born post 20th February will not get citizenship?
That's a fantastic question. And if, so the hypothetical, which is an unlikely scenario, in our opinion, that the court will rule in favor of Trump's executive order. But if the executive order is upheld, then the executive order is upheld.
Yeah, and meaning after effective February 20th, 2025.
Yeah.
Which,
but here's the crazy thing. You apply, you get a birth certificate, you could get a passport, and then what? They take it from you?
Yeah, and well, that's that. You know, in theory. So I'm gonna maybe explain it because you bring up a good point. So in this world where the executive order is enjoined, you're imagining a scenario where little Bobby's born, right? Shiny new baby, and you say, "Got to get my U.S. citizen baby a passport." And that passport, you know, it's a 5-year passport is typically what they'll give to a kid. Suddenly, not only do you have a birth certificate that evidences your U.S. citizenship, you have a passport from the U.S. government, which is going to be evidence of you. Yeah. How do you put that back in the box? Is a really.
And that's why I think it's extremely unlikely that the court is going to agree with the president order as written, and is going to strike it down, and then something else may replace it. If the Supreme Court gives the president any backdoor opportunity to come out with a modified executive order. But if they don't, it's done. But to answer his question, it is going, if the Supreme Court does the unthinkable, and they're not stupid people, to say, yes, it's totally valid, as is with the effective date, yeah, it'll be a dilemma, but it has to become enforceable.
Yeah, well, we'll have a lot of, we'll be having a very interesting YouTube session on the subject, that's for darn.
It'll be crazy. I mean, I think he needs at least another 4 or 5 Supreme Court justices appointed of his choice, and a lot of good luck for that to happen. So that's unlikely to occur in that scenario, but that's a great question.
Yeah, I have talked privately, and I said, well, you know, I could see how they could at least make an argument for those who are unlawfully present here. Not one of which I would agree with, but I mean, people who are lawfully present, you know, you went to the United States consulate to get a visa and asked to enter the country. How are you not subjected yourself to the laws of the jurisdiction of the United States? It's ridiculous.
Right. Yeah, that's why. Hi, I came on advanced parole and got an I-94 for a year that will expire on March 1st, 2025. Status is showing as DA, working with the same employer who will file H-1B. It is valid for another 1.5 years. I am not using EAD.
Yeah. Oops.
So the question is, what will be a new validity for I-94? So, okay, yeah, we got a little bit mixed up here on the question, Brian.
No, but maybe I'll go back to the first one here.
I'm not using EAD.
Yeah.
Okay. So, is there a question?
Yeah. One. What will be my status after 3/1/2025? Will it automatically change to H-1B? What will be the new validity of the I-94?
So, if you you came back on advanced parole and you filed for an H-1B, the informal policy that USCIS has used for 3 decades or more, that you get back on H-1B if you join the same employer and the employer filed for an H-1B for you, and they're honoring that.
Yeah, so
the date on the I-94 is going to be the H-1B approval date.
Well, I'm not sure. I think Tech Dreamer is asking a different question.
Okay,
saying,
yes, help me out with that. I don't understand it any other way.
Well, I think Tech Dreamer is saying, okay, so I'm looking at the CBP website, right? I was issued 994 that says DA, one of these parole I-94s that says my status expires on 3/1/2025.
Right.
What happens to me? Do I need to do something before 3/1/2025?
But his employer filed for an H-1B for him. So go back to the.
Let me see here.
I thought I came on will expire showing. Working with the same employer who filed an H-1B, it is valid another 1.5 years.
Okay, so you're presuming that H-1B is filed after he returned to the United States on that advanced parole.
That's an excellent point. So I assume that you assumed before.
Yeah, that's what I
think your assumption probably more valid.
Yeah, because okay, so
working with the same employer who filed H-1B that's valid for another 1.5 years. I'm not using EAD.
Yeah, well, he's working for the same employer. Yeah, who filed. So maybe let's answer
both ways.
Yeah.
If the H-1B was filed before he entered on advanced parole, let's answer that part.
So scenario is this: Tech Dreamer gets an H-1B that's approved until another 1.5 years from now. So what is that? Mid-2026, right? And then using that advanced parole, leaves the United States, re-enters an advanced parole. He enters as a parolee. He's in a period of time what we call POSAG, period of stay authorized by the Attorney General pursuant to having an I-45 and pending. And that's what he is When his 3/1/2025 I-94 ends, they parole I-94, nothing changes. That I-94 stays as it is, and you're left in the United States pursuant to a period of authorized stay because you have a pending green card. Now,
Can he continue working
yes,
for
pursuant to,
the H-1B employer?
correct. They'll honor that H-1B work authorization.
Yes.
Now, your version, Sam, what happens if they file that H-1B after he entered
So
the
he
United
entered
States?
the United States on advanced parole and then an H-1B filed after.
Yeah.
And then the question is where I'm at. I have 1.5 years left. You're on H-1B.
Yeah.
If it's approved after you entered and
They put you back on H-1B.
Yeah, your I-94 valid until then. Now, what's the difference between my scenario or your scenario legally? Your scenario, he remains on advanced parole until such time he filed an H-1B. He's a parolee.
Yeah, he's a parolee.
But he's
period of
authorized to
authorization.
work because
Yeah.
of the policy that was in place 30 years ago,
Yeah.
that he can continue working because he joined the same
Pursuant to
employer.
the H-1B, yeah.
Pursuant to the same policy,
Yeah.
if he filed for an H-1B, he now changed his status. Now he's not a parolee. He is on H-1B. That's assuming he filed the H-1B after he entered the United States, and he remains on H-1B.
So I guess maybe I'm going to try to say it again to maybe make it super simple. If you enter the United States, returning to the same employer, I think we've covered it. So.
Yeah, we've covered it. Yeah. All right. And if you don't, just play that YouTube again.
Yeah.
And let's go to the next one.
Yeah. So from Waihori, people with withholding of removal, are they removable?
Well, you have a withholding, right? And that withholding is permanent, but you can go back to they can bring you back to the withholding of removal is a right that you're given when you applied and the court says we're going to withhold it for, because you've met the withholding of removal standard. You could be brought back to the court and the court can revoke the withholding of removal, but I think it's going to have to be through the court action again to remove what was that through a legal process.
Yeah. So, hey, I got, sorry, I'm going to say it with more emphasis. Hey, I got an AP and EAD combo card based upon I-45 National Interest Waiver, currently on F1 OPT. F1 expired. Is it safe to travel using AP? I have clean records.
Yeah, I mean, we have this thing that they're saying they're scrutinizing adjustment of status. I mean, advanced parole. But I mean, based on what you're telling me, I have no problem with you traveling and coming back. But there is a practice alert here regarding parole.
Well, you know, they say this practice alert says, you know, pursuant to all these executive orders, you know, adjustment of status, all your paroles are still valid. But here's what I always have to say. People always ask this question of immigration attorneys. Is it safe to travel? Is it guaranteed I'll be able to come back to the United States? It's a fundamental question that people ask. And here's what our good friends at AILA say. Members are cautioned that admission with the I-512 remains discretionary and is not guaranteed, and that's always the answer. You know, just because you had an advanced parole doesn't mean that travel is safe, fundamentally. You know, that's it.
So there has been, the problem is that there has been some cancellation of certain programs that people were coming in on parole.
Yeah.
That's not related to adjustment of status.
Yeah.
And I'm reading this and trying to make sense of it. So there has been an alert that was issued at the border to carefully scrutinize advanced paroles. And they also have, through communication channels, confirmed that paroles for adjustees are perfectly okay. There's nothing wrong with them.
Yeah.
However, you have officers now who've been told, be careful with advanced paroles and review them very carefully, because some of them, for the Cuban, Haitian, and Nicaraguan and Venezuelan parole program has been canceled.
Yeah.
And because of that, there has been an alert at the border to be careful with approving or admitting people on parole. Because of that, there is a fear that they may be confusing one with the other.
Yeah.
And therefore, be prepared for long delays, be prepared to go to secondary inspection, and be prepared for your documentation get reviewed very carefully when you're entering the U.S. But there is no information that says the advanced parole for adjustment of status has any problem, except the fact that they're looking closely at them right now.
It's a fair answer. If you ask me the question, is it safe to travel? My answer is going to be the thing I learned during like the first week of being an immigration attorney. Who's guaranteed entrance to the United States? It's U.S. citizens with their passport in hand. Is my sort of baseline answer.
And if you're traveling just for sightseeing, postpone it.
Yeah.
If you have, let's say, a brother wedding or a sickness in the family or a court case you have to go to, do it.
Yeah.
Right now, there's a confusion period. There's a lot of turbulence.
Yeah.
And I just waited out for 60 days, 90 days.
Yeah, what I usually tell people is don't let immigration policy and paranoia rule your life. Live your life like a normal person. But yeah, I think your analysis on that is that's a pretty sound one in my opinion. A good summary.
All right, let's take the next one.
Yeah, from Chakshu Agarwal. I'm thinking of founding a single member LLC for software as a service startup that my spouse will manage as an LLC managed by manager. Can you please suggest a better option? Self H1B. Let me see here. Self H1B for software architectural, or this LLC signs a contract for hiring me as a software architect with a contracting talent provider company. Is there more to this? I don't see any more of it.
Okay, so he's creating a company. He wants to file for H1B for himself.
Yeah.
Obviously, if you remember, they will approve it for 18 months initially, and you have to create a mechanism by which there is a separation of control. There has to be some kind of a board member. You can create a board member in the LLC in the bylaws to create an independent board.
That's the new ones. Basically says if you own more than 50% of the company, you can basically do executive leadership, company management activities as long as it's under 50%. Yeah.
As long as
it's under 50% of your time is devoted to those management duties.
Well, you got it.
Yeah.
Explain it.
Okay. So under the regulations that took effect on the 17th, it says that when you maybe this is what you're saying. Maybe I'm just misunderstanding.
No, it's okay. You're maybe go ahead and say it your way.
Basically, if you own a company, if you own even more than 50% of the company, an H-1B worker can spend more than 50% of their time on a managerial leadership duties for a company, as long as less than half of the time is devoted to that. It's kind of basically you have to be spending most of your time on a specialty occupation, right? That's the rules on that. But correct. I'm not even sure, I'm bringing it up saying I'm not even sure Chakshu is even asking about that scenario, because this is talking about, I think they're talking about a single member LLC that is owned and managed by their spouse, essentially, meaning it wouldn't be owned and managed by, Chakshu, the individual.
I would say that he has significant control over his wife.
Sure.
And I don't think USCIS will buy that.
Yeah.
So
sure. I'll say I'll give you that. It's the same difference. Yeah.
Yeah. So for a self-employment, for H-1B for self-employment, okay, the hiring and the firing, they wanted the separation of that. They wanted that the ability to hire and fire is separate from him, and I think that's set up mentioned in the regulations.
I'm not sure. I will agree in the new version of the regulations.
Yeah, I'll show it to you.
Yeah. Okay.
And it requires that separate. You cannot, it's self-employment H-1B.
Yeah.
Okay. If you own more than 51%, right? Mm-hmm. But the employer-employee relationship has to maintain where you cannot control that. That's, I think, what they're saying. But let's go back to his question.
Yeah. So he places a better option: self H-1B for software architect role, or this LLC signs a contract for hiring me as a software architect with a contracting talent provider company. So maybe I'm not understanding the I think our big problem here is we're getting lost in the reeds because I'm not quite understanding Chakshu's question is the bottom line there. I think is my fundamental problem, because you and I seem to be speaking different languages on this subject. So maybe this is sort of one we're going to have to say mulligan. And Chakshu, if you give us some explanation, we'll try our best.
Yeah, maybe we're not understanding the question to be able to answer. Yeah.
So, Raj Channel, my EB2, Rest of World, AOS is pending. Do you think it'll be impacted by the new executive order of extreme vetting, such as mandatory interview and longer processing time. Thanks in advance. I think this just falls in the remains to be seen category.
But there's nothing additional for me to say it will be impacted. You know, you're going to get your green card in time. It's so backlogged. This is alone does not call for extreme vetting.
Yeah, I mean, I'm gonna. Yeah, it depends. It really. I mean, extreme vetting is really a part of that. Is the rest of the which country you're from as well. If you're from a country that they trust, you are less likely to be subject to additional scrutiny. Is the bottom line. Yeah. So Empire giving a little commentary on Birthright. They want to argue an invading force children aren't U.S. citizens, but neither undocumented or documented immigrants are an invading force, even if the rhetoric is the U.S. being invaded. Yeah, that's the theory behind basically taking away birthright citizenship. And again, for people who are duly issued, who went to the consulate and said, hello, I'm being offered employment in the United States for a working visa. U.S. government, would you give me a visa? You know, it's really hard to say those people are an invading force when, you know, nice folks at the consulate say, here you go, have fun in the United States, my friend. And again, invading force, even for those who are undocumented, I mean, so many of them have asylum applications. You know, how can you be an invading force if you're saying, I'm saying the place I'm coming through is no good.
No, the invading force, I think he's talking about the exception to the 14th
Well,
Amendment.
exactly. Basically, that is, you know, an invading force if they have children in the United States. But again, if the people who, presumably the people who are here enter the United States illegally, they're arguing those are the
invading force.
Now, as soon as that invading force, members of the invading force apply for asylum in the United States, the premise of an asylum is, I can't go back to my home country because it's not good for me for any number of reasons. It's really hard to sort of, you know, buy into that concept of an invading force is how I see it. Yeah, let me see here. Can an H-4 holder travel outside the United States if she and her spouse, H-1B holder, apply for adjustment of status? And for BA, the question is, your H-4 is valid so long as your spouse remains in valid H-1B status. You're not required to be attached at the hip and be where they are at all times. But the practical question is, I would ask you of your H-1B holder spouse is, hey, are you still in valid H-1B status? Because even though it falls in the category of how are the customs folks going to know, but if you're not in valid H-1B status anymore, an attorney like me would, as soon as I figure that out, I'm going to say, well, technically you can't enter the United States on H-4 if your spouse is no longer maintaining H-1B. And I'm going to probably say it just like this too. Yeah.
All right, let's take the next one, Brian.
Yeah.
All right, censure. A lot has happened since the Second Amendment was codified, and do you think that it's going to stop the administration from doing wild things? Of course not. Yeah. Of course not. And it's the 14th Amendment, I think you're referring to.
Yeah. The Second Amendment is what the right to bear arms, but maybe they're sort of using that. But you know, the sort of conservative view of amendments in the Constitution is the original constructionists. What do they mean at the time it was issued? And again, it's really, it seems to be that when we read parts of, I mean, we've read it in the past, but we looked again at Wong Kim Ark, the Supreme Court case. They went back to, you know, English common law to see what, you know, what is the meaning of subject to the jurisdiction thereof. And if these guys do what they say they do, we're going to think about what it meant to the people at the time of this case. Going back to, you know, English common law is what those Supreme Court justices should believe right now if they're intellectually honest. Meaning, I just don't see how these crazy things get around that.
Well, right now the executive order is so encompassing.
Yeah. And
the invading force argument, as we have discussed, it could get some justices' attention, but I don't see how legally allowed people to enter the United States can become invading force.
Yeah, it's quite the stretch. That's for sure.
Yeah.
I mean, here I'll give you. I'll spare you my analysis of how they get there. So here's one I've been thinking about, Sam. Will there be any change in success rate with the new administration if we do a mandamus for delay? And
That's an excellent question.
yeah, I'll tell you what I'm thinking about. I think they're going to. So if you file a mandamus for delay, the government attorney that receives that complaint, they're going to come back. Well, let's say you file a mandamus complaint against USCIS, and the government attorney is going to call up USCIS and say, "Hey guys, USCIS, Runyon has sued you for being too slow, and I have two options here. I'd love it if we could resolve that court case if you guys could just approve this thing and be done with it. Fantastic. Or if you give me a really, really great reason to fight this thing, I will fight it for you." And USCIS response is, well, we have an executive order that says we are required to engage in high scrutiny on these cases, additional security screening, and we need time to do that. And that government attorney, unless they really don't like their job, they can't really go against that. They are going to be forced to fight those cases. That's the. So it's weird. Sam and I were just talking about this. So shooting some messages back and forth. Maybe it was Sunday evening. It was, I'm sitting here thinking, well, gee, there goes, is your likelihood of mandamus actions, does it go down? They're going to fight more? Maybe, but it's more mandamus actions, because if they're slowing down more cases, it's going to be more people motivated to sue to get them. And eventually there has to be a breaking point. Because if they perpetually hide by the idea of, I need more time for security screening, you cannot hide forever. That's the whole point of a mandamus delay suit.
We're going to be obviously doing more mandamuses because of the delay. I mean, with the hiring freeze and the agency spending more time on scrutiny and looking under every stone in their path. Is going to slow things down.
Yeah, I mean, one of the things on my list, Sam, is the order reading is, evaluate whether there's certain countries from which we can just say no more immigrant visas. I just don't buy that they can do that. They can say we need more time to screen them, but I just don't say we can but then they can. It's consular non-reviewability. We determined your security. It's a very interesting thing, and lawsuits is how I sum up that topic of conversation.
Yes, unfortunately, your resort is the judicial system when the case is delayed, and if you're gonna get some good judges, you're gonna get some bad judges. And you're gonna get but some cases you're gonna get mandamus order. And that's a good thing. So, yep. Well, we've crossed the 7 o'clock. We'll take the last one, Brian. So we're not disappointing one less person disappointed. Pick one here, and we'll take it.
Yeah, I'm going to just hit the next one in line here.
Hi, Brian and Sam. I have EAD advanced parole until 2029. If I travel, should I use AP or H-1B to return? Also, do you think priority date September 13, 2013, AB3 will be current this year? Is USCIS likely to require interview? Between the advanced parole and the H-1B, Brian, which one do you prefer? I prefer H-1B.
H-1B. Yeah. Always going to be that.
Yeah. So you get your stamp. You're on non-immigrant visa. That's a good thing because you have an adjustment status and you have an EAD, so you're protected and you're inspected, and that's nice to have because parole people have slightly less legal right in the U.S. Priority date September 2003 will be current this year. Brian's going to look up the visa bulletin. And if I can go back to the screen, Brian, I can answer the next one as you're answering, as you're looking up here. Will USCIS require an interview? It's very interesting to, it's very difficult because during the Trump 1.0, we've had a lot more interviews.
Big mandate. Everybody gets interviewed.
So are they going to go back to that? It's hard to say, but I don't see how Trump 2.0 not going to be the same as Trump 1.0 unless he figured out it's a total waste of time, and that's not how you figure out whether somebody is legitimately deserving of the green card or not by interviewing them. But that's remained to be seen. We do not know. With regard to the visa availability, Brian, what do you got?
So I have the chart I have up here, Sam, is the dates for filing for, well, everybody here. And I'm looking at the dates for filing for India. This is for February 2025. That's where I presume on where you're from here. They're in, EB2 is in January 2013. EB3 is in June of 2013. If the point of, as they would tell us in the past, the point of the dates for filing is where do we think we can get to in the foreseeable future? And if the foreseeable future is only, best case scenario, EB3, 8th of June 2013, it doesn't seem like that they could get to September 2013 within this year, is that?
As we see it now.
Yeah.
So maybe next year, we hope.
Hey, Sam, maybe this will be my final thought on the subject. So back in, 2015, I think it was, suddenly overnight, the dates for filing appeared, right? And they were kind of neat because they allowed people to file for green cards, get work authorizations sooner than they might have been able to in the past, right? Can that go away?
Oh, yeah, easy.
Yeah.
Very easy.
Yeah, it's an interesting little epiphany I had.
It can absolutely go away, the dates for filing, which probably create more confusion, but they provided more opportunity to people apply early, which is nice.
Yeah, but I don't think this present administration wants more opportunities for people to say, I don't know, have the benefit of a pending green card to stay in the United States or get unlimited work authorization. Yeah,
Well, they haven't tackled the employment immigration piece.
And that's when I say, for everybody in the audience who's, that's like giving myself a high five here. It's
not on their radar.
They're not interested in it. Well, I just saw a headline today from Donald Trump on H-1B visas. Donald Trump H-1B. It's a good one, and I maybe sorry, Sam. Let me see here. I could have swore I saw it. President Trump standing birthright citizenship. Oh well, a great quote from him, basically saying, here we are. That's 5 days ago. I don't know. Well, here it is. This is just an MSN article from USA Today. Donald Trump and Elon Musk are pushing the H-1B visa. Does it take American jobs? They're pushing it, for the H-1B visa. I saw a great quote from him today. It's just going to be annoying that I can't find it. Well, I'm not going to worry too much about it anyway. Yeah. Donald Trump seems into H-1B visas for the time being, which is probably good for everybody in our employment.
But not their children. With that, we end today's session. Until